Chairs just have yellow and black tape on it. Just have a chair. Just have a seat. That chair doesn't have the one on the end does. There's some back there, some over here. Chairs just have yellow and black tape on it. Just have a chair. Just have a seat. Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. This morning we have our arraignment docket, and you have been asked to come to court for arraignment. What the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a misdemeanor case. It is a criminal case, and criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about is the facts or circumstances of the offense and the possible punishment that a person can receive if they are convicted of the offense. Now, if you had a felony offense, it will fall into one of 5 categories, and we'll start at the top. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If you're convicted of a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if you're convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, the offense that you have is not a felony, it's a misdemeanor. And misdemeanors are divided into 3 categories. And we'll start at the top and go down. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor, which is the lowest misdemeanor. Class C misdemeanors are normally handled in the JP court or the justice court, or the city court, which is the municipal court. However, those cases come to this court, County Court at Law, if you appeal your case. For example, you're convicted in the JP court or the municipal court, and then you file an appeal, then it comes up to this court. Now, the range of punishment is the same. It does not change. So the range of punishment for a Class C misdemeanor is by fine only. You only can get a fine, and normally the fine is usually up to $500. Now, if you are convicted of a Class B misdemeanor, the range of punishment, minimum 0 days to maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000. If you're convicted of a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, and a fine that does not exceed $4,000. So it's $0 to $4,000. Now, as a defendant in a criminal case, you have rights. And the first right that I'll talk about is your right to have an attorney. Now, on the clipboard that has been handed out to you, the first sheet is titled Judge's Explanation of Rights to Defendants Without an Attorney. It talks about your right to have an attorney. Now, it says as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Number 3, if you want to waive your right to have an attorney to represent you, which means to give up your right to have an attorney to represent you, and you desire to represent yourself, then you can do so. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire. And that financial questionnaire is on the clipboard. It is titled Jefferson County Affidavit of Indigence. You would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to give up your right to have an attorney and you want to represent yourself, if you do so, you'll be able to speak to the prosecutor about your case. However, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. And the written waiver is the second page on the clipboard, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities, such as military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to you by the court. At the bottom of that document, it is in bold print. It states, defendant's choice, marking issues next to only one choice. Now, if your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney or give up your right to have an attorney to represent you and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that is titled defendant. And you will date it today's date on the line that is titled date. And the day's date is October 3rd of 2023. Now, for those individuals who will be waiving their right to an attorney or giving up their right to an attorney and desiring to represent themselves, then you would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that's the second page on the clipboard. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that you are doing this of your own free will. Nobody's forcing you to do it. And it's intelligently made. Intelligently means you know what you're doing. Furthermore, I have been advised this third day of October of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have further been advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, October 3rd of 2023. Now, as I mentioned to you earlier, you have rights. The first right, I just finished going over that right, which is the right to have an attorney. You also have a right to have a jury trial. For those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case. They will listen to all of the evidence, they will listen to all of the arguments, and then they will deliberate, and then they will decide to find you not guilty or guilty. Now, you have a right to waive, which means to give up your right to have a trial by jury. And by doing so, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial. And what a bench trial basically means is that you'll have a trial, but it will not be a trial with a jury. It'll be a trial by judge only. The judge will listen to the evidence, listen to the arguments. The judge will deliberate and decide whether or not to find you not guilty or guilty. Now, you have a right to waive your right to have a jury trial, waive your right to have a bench trial. And by doing so, the second way that your case will come before the judge is by way of an agreed plea bargain. And what a plea bargain is, it's an agreement that you have worked out with the state to settle your case. So if you work out an agreement with the state to settle your case, we call that a plea bargain agreement. That agreement will come before the judge, and the judge can either accept or reject the plea bargain agreement. Now, if the judge accepts the plea bargain agreement and you decided that, well, you think that you've been wrongfully convicted, or the court committed an error by convicting you, and you would like to appeal your case, that is to have a higher court to review your case to see whether or not this court committed an error by wrongfully convicting you, or you have basically, the court either committed an error or you've been wrongfully convicted. Now, if that's the case, and if the judge follows the plea bargain agreement, you have to get permission to appeal your case from the judge. And if the judge gives you that permission, then your case will go to the Ninth Court of Appeals, which is right upstairs on the 3rd floor. They will review your case. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than the ninth court. You can appeal it to the higher court. The highest court that you'll be able to appeal it to is the Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you will have to file what is called a pro se petition for discretionary review. And basically what that means is this: pro se means you're representing yourself, you don't have a lawyer representing you, and you'll be asking them to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court has committed error by convicting you. If they grant your pro se petition, then at that time, they can simply find you not guilty, or they can send the case to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a whole new trial. Now, if the court don't grant you a right to appeal your plea bargain agreement, then you can't appeal it if the judge follows the plea bargain agreement. Now, the third way that the case will come before the court is by way of an unagreed plea bargain agreement. What that means is you and the state have talked, y'all have not been able to reach an agreement, and so therefore you want the judge to set your punishment. And so the case will come before the judge, and the judge will set your punishment. Now, the other way, the other right that you have a right to have witnesses to come to court. And when Deputy Hinton is sitting there, we call that the witness stand. And what a witness does, the witness can testify either for you or against you. If you're represented by an attorney, they can ask questions, or if you represent yourself, you can ask questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court as well. Now, if you waive or give up your right to have witnesses to come to court, that means you will not be calling witnesses. It does not mean that the state or the district attorney will not be calling witnesses, because they will be calling witnesses in the case. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your trial. The state can't not call you as a witness. They can't force you to testify in your trial if you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, if you waive or give up your Fifth Amendment right against self-incrimination, you can testify in your case if that is your desire. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence or to discover what's in the state's file. You have a right to see any documents like witness statements, your statement, police reports, lab reports, any statements that they may have that they'll be using against you. You also have a right to see videos, hear audio recordings. You have a right to see the objects that they'll be using in your case. Now, you also have a right to waive or give up your right to have discovery. And by doing so, you will not be having access to the documents, to videos or audio recordings or any instruments that they'll be using as evidence in your case. Now, everyone here that's here for arraignment, you have been arrested and you are out of jail on bond. You're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you have spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. The 5 days in jail, and let's say the state is offering you in your plea bargain agreement for you to serve 5 days in jail. Well, that simply means that you will not have to serve any more time in jail. Why? because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means that you only have to serve 2 days in jail because you're given credit for the 5. 5 will be taken from the 7, so that leaves 2 more days left. Every day that you spent in jail can also be used as credit towards your fine and court costs. Every day that you have spent in jail, $100 per day will go toward your fine and court costs. So for example, if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means that you will not have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be taxed and retired. You won't have to pay it. Now, if they're offering like $700 fine and court costs and you spent 5 days in jail, you have $500 credit. You're going to take that $500 from the 7. That means you'd have $200 to pay. Now, you will pay the $200 on the day of the plea. Now, if you cannot pay the $200 on the day of the plea, the law allows us to allow you to pay it off in installments, which means you could pay it off in monthly installments. Now, even if we allowed you to pay it off in monthly installments, you still may not be able to pay it off. And if that's the case, then we can convert the $200 or the balance to community service. And you get $12.50 for every 1 hour of community service that you do. So if you perform 8 hours of community service in one day, that's $100 that will go toward your fine and court costs. So in the scenario that I gave, you owe $200, you work 2 8-hour days at a nonprofit organization, then that would be $200 go toward the fine and court costs. So you won't have a balance, you'll be paid it up. The other thing is Jefferson County has a program for first-time offenders. If you haven't been in trouble before, first time getting in trouble, then Jefferson County has a program that is called pretrial diversion. When I say Jefferson County, I'm talking about the district attorney's office. With pretrial diversion, you get into the program, they will dismiss your case and you can get it expunged from your record. Expunged means erased, wiped off, or deleted from your criminal record. Now, in order to qualify for that program, it has to be your first time getting into trouble. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with writing the application to get into the program. And so again, with that program, the case, you get in the program, they dismiss the program. Once they dismiss the program, if you complete it, then you can get it erased, deleted, or wiped off from your criminal record. If you're a veteran of any one of the branches of the United States military, Jefferson County also has a program that is called Veterans Court. It's a program for veterans only. And if you're interested in that program, we have Wade here. He's going to come up a little later and tell you more about that program. But basically, you'll get into the program, you complete the program, and you can get what is called a non-disclosure. And what a non-disclosure is, a non-disclosure means that we cannot disclose the fact that you were on deferred probation to the general public. We can't disclose that, and that's what it's called, a non-disclosure. Now, this court has a program that we call the CSI program. The CSI program stands for Community Safety Initiative. It's a program that I started within the first 100 days of taking office back in March of 2017. In that program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop is our local mental health center. And with the Spindletop Center, they're going to come to you a little later and tell you more about their program. But basically, with the Spindletop program, they're able to conduct private interviews. They can do an assessment, develop a treatment plan for either outpatient or inpatient services. As for individuals who have mental health issues, and you do not have to be incompetent or insane to participate in the program. You may have anxiety or depression or any other host of other mental illnesses, but they can address that for you. The other thing is Spindletop also has a drug and alcohol program. But the drug and alcohol program is called ATAR, stands for Addiction, Treatment, and Recovery. Also, we have a partnership with our local Drug and Alcohol Council that has a program called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs, the ATAR program and the OZAR program, are similar programs in that what they will do, they can provide a screening, an assessment, and you could either be referred to outpatient or inpatient treatment to address whatever alcohol or drug issues that you may have. Now, if you're unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, well, the CICE program has a GED program as well, where you could get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you, the county, anything. Only thing it costs you is time. And in this court, we do not just give time, we take out time. And that basically means we do not just arrest the problem, we address the problem. And we believe by addressing the problem, we can produce productive people. And if we produce productive people have too much to lose, so therefore they will not commit crimes. And so therefore, I like to say that when you come to county court at law number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their lives, we're going to make a difference in their home. And if we make a difference in their home, we're going to make a difference in the community, because what comes out of the home goes into the community. And so therefore, with this program, we believe that we can make Jefferson County a safer place for all of us to live, work, go to school, raise our families. Now, if you're interested in the program, just please let us know. We have some brochures that we can give to you. And as I mentioned earlier, we have Deputy Hinton and Gabby who can come forward to talk to you about the Spindletop. And we also have Wade, who is going to come with the Veterans Association. He could tell you about the Veterans Court. Which one is going to first?
Yeah, y'all.
Okay, Wade.
Thank you, Your Honor. Good morning, everyone. My name is Wade Adair. I'm a veteran coordinator with Spindletop Center and Texas Veterans Commission. I'm here with the Veteran Care Coordinator, Lori. And we're here to talk to you. If you're a veteran, we'd like to talk to you today about the Jefferson County Veteran Treatment Court. The judge mentioned it. I'd like to give you some more details and talk to you about how you can qualify for that. If you're a veteran in here, we also, out of our offices, have resources and benefits for veterans. We'd like to talk to you what's available. And if you're a family member, that applies to you as well. Spouse, children of a veteran, we love the opportunity to speak with you. We'll be here. You'll just please let us know. We'll come and visit with you. Thank you very much.
Okay, thank you, Wade.
Thank you, Your Honor.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. This is my coworker, Gabby. And also this is Wade. Now, the reason we're all three here this morning is because the judge graciously invited us in his courtroom because he cares about every single person who comes before the bench. Now, what the judge has found, and the statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation.
And we can understand being here is not the easiest thing. You may put a lot of stress on your life, financially, family, or just in general, anxiety, positive anxiety. And, when we talk about anxiety and depression, these are things that happen to a lot of people. It is common to have being anxious, being in court or just life situations. Or it can just be chronic sadness of your situation right now, and it can be not only just mental health, but also situational too. And so that's why we're here to help you always.
Maybe this is your first time to be here, maybe it's your 10th time to be here, there's still hope. What we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us. And the demographic sheet that she handed y'all when y'all came in, she's gonna explain how you can use that and how you can share that need with us very privately. This is not a court document that's gonna be shared with the court. This is only shared with us so that we can best see how to fit you into services that best suit your particular situation.
And so with this document, this just allows you to contact you once, so be by text. If you don't have a phone that receives text, just please let me know and I'll be able to give you a call. But if you do want to call after that text, I'll schedule up a phone interview, that won't interfere with your mind. I don't wanna call you in the middle of work or something, so just let me know, in that text, what works best for you if you do want to call. But this just allows me to contact you once. It's not gonna be automated. It's gonna be by me on my work phone. And so, the only person who will receive this information is, this information not gonna be given out to the department. This is one of the most important things is just getting a good number for us, and also it says, resource requests on here. You can check either one, or if you have another one you want to fill in, please do. And also, like you said, the veterans part right here is on the bottom, so if you have served before, please mark either yes or no here.
Also, before you leave here today, I want to get this flyer in your hands. It tells you the advantages of participating, but it also has a 1-800 number should you find yourself in an unsafe place. You can call that number immediately. Now, Wade also has a flyer for any veterans that are here. We want to get that in your hands as well. Just make sure we know about it so we can argue with information and best suit you and your situation. Now, just shortly, the court is going to go into recess, and when it does, we'll be able to come out there, we'll pick up those forms from you, we'll answer any questions, and I'll get this in your hands as well.
Thank you,
Thank you,
Jackie.
Your Honor.
Deputy Head. Okay, ladies and gentlemen, the paperwork that's on the clipboard, we have some court personnel who is going to come out if you need some assistance with filling that paperwork out. When our court personnel comes in, just raise your hand and they'll come out and help you. Now, it's going to take us a little time to pick up the paperwork from you. So if you finish the paperwork and you need to use the restroom, there are 2 restrooms right outside the door in the hallway. The female restroom is on the opposite side of the hall in front of the 172nd District Court in the corner. And the male restroom is next door in front of County Court at law number 3. Now, as I mentioned earlier, if you need to use the restroom, you can use those restrooms. Now, do not leave the courthouse because we have not finished with your case. Now, if you leave the courthouse and if we call your name, and if you're not here, your bond will be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. So this is going to take us a few minutes to help with the paperwork, to gather the paperwork. And then once we finish with that, we're going to call you up before the bench one at a time. And then we're going to put you in 1 of 3 categories. And then once we finish here, you'll be free to go. Okay? So at this time, the court will be in recess. And I think folks from Spindler Top is going to come out and talk to you. So we can see the prosecutor. You got that up?
What in the world?
Is that one? Is that one right there? But I'll put it up some, just the way you can see his head. Yeah, and then turn it a little bit more way. See part of the bench. Right there. Right there. Right there.
That's good. People can see it right now? It's on right now?
Yes. Jefferson County Court at Law Number 2 is now in session. The court is in session and calls number 23CCCR 0402 case of Style of State of Texas versus Joshua Jamon Thomas. Mr. Thomas, is that your full name?
Yes, sir.
Mr. Thomas, would you please raise your right hand? Mr. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thomas, you may put your hand down. How are you doing, Mr. Thomas? You doing all right? That's good. Now, Mr. Thomas, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Thomas, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you want to reset your case to hire your own attorney? Okay. Now, Mr. Thomas, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Thomas, I read your answers. Based on your answers, your case will be reset to give you an opportunity to hire an attorney. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. And you have a blessed day. Please have a seat at the first chair on the wall. Next case is cause number 23CCCR 1172. Case is Style of State of Texas versus Arvell Edwards. Arvell Edwards. Mr. Edwards, your full name is Arvell Edwards?
Yes, sir.
Mr. Edwards, would you please raise your right hand? Mr. Edwards, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Edwards, you may put your hand down. How are you doing, Mr. Edwards?
Pretty good, sir.
That's good. Now, Mr. Edwards, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Edwards, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? And are these your initials on the line say you want to apply for a court-appointed attorney?
Yes.
I also have a document that is titled Jefferson County Affidavit of Indigence. Mr. Edwards, do you recognize this document?
Yeah.
On page 2 of this same document, there's a signature above the line that is titled Defendant. Signature. Is this your signature?
Yes, sir.
Now, Mr. Edwards, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Edwards, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair by the wall. You all. You have a blessed day. The first one on the wall, right. Next case is cause number M327432. Case is styled the state of Texas versus Xavier Holloman. And your full name is Xavier Holloman? Ms. Holloman, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Ms. Holloman, how are you doing? I'm doing fine. Thanks for asking, Ms. Holloman. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Holloman, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Holloman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact Mr. Matuska. Our court coordinator will give you that information. Once our court coordinator gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Thank you. Next case is cause number 23CCCR 1556. Case is styled the state of Texas versus Jacadron Darquise Scott. Mr. Scott, your full name is Jacadron Darquise Scott?
Yes.
How you doing, Mr. Scott? That's good. Now, Mr. Scott, would you please raise your right hand? Mr. Scott, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Scott, you may put your hand down. Mr. Scott, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And is this your, or are these your initials on the line state you want to apply for court-appointed attorney?
Yes, sir.
Now, Mr. Scott, I also have another document here. This document is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Scott, before you signed and initialed these documents that I just showed you, did you read the documents?
Yeah.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Scott, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Laura Peraza. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Have a seat in that fifth chair. That's 2 seats over from the young lady. Right there. Next case is cause number 23CC Sierra 0742. Case is styled State of Texas versus Zachary P. Broussard. Mr. Broussard, would you come forward?
Thank you.
Mr. Bruce, that door is locked. You gotta go through the other door. Mr. Broussard. Your full name is Zachary P. Broussard?
Yes, sir.
Mr. Broussard, would you please raise your right hand? Mr. Broussard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Broussard, you may put your hand down. How are you doing, Mr. Broussard? You doing good? That's good. Now, I'm doing fine. Thanks for asking. Now, Mr. Broussard, I have before me a document that's titled Jefferson County, Attorney Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Broussard, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? And Mr. Broussard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Okay. This will conclude the calling of the arraignment docket.